Every person has the right to transfer his property, but such right should be exercised bona fidely, not fraudulently. Basing on this, we shall read Section 53 of the Transfer of Property Act, which is dealing about the fraudulent transfer. We shall read the fraudulent transfer basing on two situations. First situation, when the motive of the fraudulent transfer is to defeat or delay the creditor, the interest of the creditor. That means there are three parties: the creditor, the transferor, and the transferee. Now, the creditor has an interest upon the property of the transferor, but the transferor is fraudulently transferring his property to any purchaser or transferee. The ultimate result is a fraudulent transfer to defeat or delay the interest of the creditor. And there is the second situation, when the first transfer was a gratuitous transfer, that means transfer without consideration or gift, and the second transfer is to the subsequent transferee, maybe by way of sale, that is non-gratuitous transfer. First is gift and second is sale. So the fraud is done to the subsequent transferee because as the property has already been transferred by way of gift, it cannot be logically transferred to the second subsequent transferee by way of sale. So the intention is to do fraud with the subsequent transferee. Now, as the subsequent transferee has given monetary consideration, so the subsequent transferee will make the first transfer void so that the interest of the subsequent transferee can be made good. So, as we can see, the principle of fraudulent transfer under Section 53 of the Transfer of Property Act, it is governing the interest of two parties. First situation, the fraud is done to the creditor, and in second situation, the fraud is done to the subsequent transferee. In both cases, the creditor and the subsequent transferee can make the transfer for other transfer void. In the case of the first situation, the rule is not applied when it is done in good faith for a bona fide purchaser. So the creditor cannot make a bona fide purchaser's interest voidable. And secondly, when the court is dividing the property under the law of insolvency, now the creditor cannot make it voidable. Ultimately, we have to remember that the intention of the fraudulent transfer is to defeat or delay the creditor. But whether the intention was such is a mixed question of law and fact. But while understanding several case laws and situations, we can say that if the transfer is made secretly and in haste, then there can be a strong presumption that the transfer is fraudulent. If there is a decree passed against the judgment debtor and immediately the transferor transfer it, then there is strong presumption of fraudulent intention. When the transferor has gifted his entire property without any sufficient consideration or before attachment, or he has gifted or he has sold it in small amount of consideration or unreasonable amount of consideration, or in the sale deed there is amount written but no actual payment is done. So these are the all situations which indicate that a transfer is fraudulent. I hope this simple discussion on section 53 has cleared your concept. I have made other videos on Transfer of Property Act, as simple as I can. To join those discussions, you have to check the playlist from this channel. But before that, please subscribe to the channel, give it a like, and comment your opinion. It is very valuable to me. Thank you.